All right. The Senate will turn to order. Moving on to Senate Bill 351. Secretary, read the caption.
Senate Bill 351 by Senators Anna Vitarte of the 31st and others, a bill to be entitled an act to amend Titles 20 and 39 of the OCGA relating to education and minors, respectively, so as to provide for social media platform access by minors, to require local boards of education to adopt, implement, and enforce social media policies, to authorize the Attorney General and the Department of Education to consult with and assist local boards of education in the development and implementation of such policies and for other purposes. The Senate Committee on Education and Youth recommends that this bill do pass by substitute. Respectfully submitted, Senator Dixon of the 45th District Chairman. The Senate Committee on Education and Youth offers the following substitute to Senate Bill 351, a bill to be entitled an act to amend Titles 20 and 39 of the OCGA relating to education and minors, respectively, so as to provide for social media platform access by minors, to provide for social media policies in public schools, to include promotion of safe and appropriate use of technology and responsible digital citizenship in the state's comprehensive character education program, and for other purposes. That completes the order, Mr. President.
Senator from the 51st, for what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that all senators are invited back to the anteroom to get a fresh apple pie from B.J. Reese's Orchard in LJ?
Oh.
So today is apple pie and Hyundai.
Apple pie and what day?
Hyundai.
Hyundai, okay. All right, good. All right. Well, I recognize the senator from the 31st to speak to the bill.
Good afternoon, colleagues. Thank you, Mr. President. Here to present Senate Bill 351, known as the Protecting Georgia's Children on Social Media Act of 2024. This bill has come a long way since I think we came up with the concept, and I first want to thank the President of this chamber, his leadership on working on this in collaboration, and the many other senators who have been supportive along the way, both Republican and Democrat, as we talk about the social media crisis that all of our kids face in Georgia, in our schools, and across the country. I'm just going to go through some of the highlights, and then I'll take questions at the end. If you'll see in Section 2.1 of Senate Bill 351, one of the things that we've updated in Georgia law is amending the existing law regarding comprehensive character education programs, adding that to start in the 25 school year by the Department of Education, also including programs, information materials regarding methods of promoting reasonable digital citizenship, which is important. Section 2.2 talks about how the Department of Education will develop and publish on its website model programs. A couple of the items discussed in the bill is touching on the effects of social media on mental health of users, how social media manipulates or influences thoughts and behaviors, and how to maintain personal security, identify cyberbullying, predatory behavior, and human trafficking on the internet. And believe it or not, ladies and gentlemen, as I have heard and seen, I know in my own community, human trafficking is real inside of our schools. That is a fact that we have to continue to combat as a state. Section 2.3 also requires in 26 the local board of education to prohibit and prevent students from accessing social media platforms through the use of their computer equipment, communication services, or internet. Section 2.4 updates and modernizes for the first time in around a decade the cyberbullying statutes in the state. Section 3.1 requires the social media platforms to make commercially reasonable efforts to verify age of account holders and treat any minor of an individual on the platform under 16. I think most of us in this chamber would agree that our kids, I have 3 young daughters, just like the president, and many of you in here that have kids and grandkids, You know, we all do a very reasonable, and probably, if you're like me, you probably go over the top to see what's on their phone and what they're doing. But I believe in this day and age of what kids are accessing and what's being put in their face, and then we can even go further with some of the national security concerns that we've seen through social media currently. Now more than ever, we need to know what's going on, and I think hold social media companies accountable in a very reasonable way. So if you're under 16, I think as a parent or guardian, we should be doing more as it relates to personal responsibility and educating our kids and protecting our kids. Finally, the bill has enforcement through the Attorney General's office as it relates to social media age verification, parental consent, data privacy, and bars private rights of action against social media platforms. And with that, Mr. President, again, just want to say that this is one of the most comprehensive updates to cyberbullying we've seen in the state in a very long time. And I also think it's a reasonable effort, more than a reasonable effort, to protect our kids as it relates to the threats from social media. And I do want to thank the industry, but I also want to thank the input that we received from school boards and teachers and parents throughout the state over the last several months, going back to last summer when we introduced this idea that we were going to pass this bill. So with that, Mr. President, I'll take any questions.
You do have one question, Senator. Senator from the 14th.
Thank you, Mr. President. Senator Yield?
Yes, sir.
Senator, isn't it true that this bill includes a number of references to parental opt-in, opt-out to give parents as much input as possible so that some of these blanket policies don't affect their kids adversely if they do want to have special access to different platforms?
Yeah, I think that's correct, Senator. At the end of the day, I mean, we're trying to empower parents to make a lot of these decisions on their own. I think we probably know better than our kids do, even though they disagree with us every day, as it relates as I did with my parents. But I think right now it's for us to have greater control over what our kids are doing and empowering households to make some of these decisions as it relates to content.
Thanks, Senator.
Thank you.
You have no further questions.
Thank you, Mr.
Senator.
President. You the will.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection or agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Question is on the passage of the bill by substitute. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 51, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Secretary reads Senate Bill. Whoa. Hold on, I was getting ahead of myself. Y'all threw me off with that first bill today. The 3-hour debate. Over giving money to HBCUs, I tell you. All right. Recognize the senator from the 19th. Senator from the 19th has moved that the Senate agree. Secretary, read the captions.
Committee of Conference Report on House Bill 915. The Committee of Conference on House Bill 915 recommends that both the House of Representatives and the Senate recede from their positions and that the attached Committee of Conference substitute to House Bill 915 be adopted. Respectfully submitted, Senator Tillery of the 19th and others. Conference Committee substitute to House Bill 915, a bill to be entitled An Act to Amend an Act Making and Providing Appropriations for the State Fiscal Year beginning July 1st, 2023 and ending June 30th, 2024, known as the General Appropriations Act, and for other purposes. That completes the order, Mr. President.
Recognize Senator from the 19th.
Thank you, Mr. President. I bring the Conference Committee report, House Bill 19, the FY24 amended budget. It looks to many of you very similar to the way the Senate budget looked when it left. The adds that we made in various areas will remain, including those made through most of the courts and the Senate. You'll also see some changes at the Department of Ag to add back $2 million for a Georgia Farmland Conservation Fund program. The House was insistent upon moving to the Senate's position on a variety of other things that we moved to their position on behavioral health matters, including the $15.5 million for a child and adolescent mental health services program at the Gateway facility in Savannah, as well as a return to the original House number on direct care support services. At various items in the Department of Community Health were plussed up based on the recommendations of our Health Committee subcommittee, and we were able to take a slight reduction in our low-income Medicaid in order to move those funds over to something that was spoken about from the well here concerning our public safety officers who are disabled in the line of duty to pay their state health benefit plans with state funds rather than those be their responsibility by themselves. At the Department of Corrections, you'll see some moves that we did to actually increase the Senate's ad on our state prisons program related to cell phone interdiction. And you'll see that the monies for those come out of the $450 million for the Davisboro project concerning a new state prison. At the Department of Education, the Senate held firm on its ESSER funding for character education to match another $10 million private donation. And we moved to the House number on testing at line 158.2. The language change that the Senate made on 168.1 to the Governor's Emergency Fund remains. We also had an increase of $1.5 million for wraparound services in our Child Welfare Services program at the Department of Human Services, and an increase in our funds related to the Department of Administration at DHS to make sure they have everything they need that we could provide for Medicaid redetermination notices and mailings. There was a slight increase at our out-of-school care services. In the past, that's been things that we've used to help support school systems and after-school training. And you'll see that we did move to the House's number at Voc Rehab concerning services and equipment for the Georgia Industries for the Blind. The House came to our position at Juvenile Justice concerning the music studios, and the House also came to our position at the Department of Labor. There's an increase at line 235.4 for outdoor recreation, state parks, and historic sites for various things that have happened concerning maintenance items there to make sure those facilities are available for what has been an increased use over the past 5 years. And at line 261.3, you'll see where the funding I told you came out of low-income Medicaid moves over to help fund and subsidize the state health benefit plan for retired individuals injured in the line of duty. At Regents, there was a slight haircut to the Georgia Research Alliance. We did fund one eminent scholar and one distinguished investigator at each of the three universities mentioned. We also included $100,000, and the House agreed with our position for a $100,000 raise, or increase rather, for the Fort Valley State University for a feasibility study for their veterinary school. At the Holocaust Commission, you'll notice on 293.3 the line moves to zero. The funds are reflected elsewhere. One of the things that we've had an issue with is funding a building for the Holocaust Commission. We probably won't be able to do the building, but we're committed to doing the exhibits. That's a word I just wasn't rolling off my tongue. I apologize. The exhibits there, they were able to provide us a list of those exhibits. We moved that money to the GISFIC program on purpose. That will allow it to lapse over the June 30th date so it can stay there for exhibits for the near future, go into future budget years if necessary, because we do think it's extremely important that our citizens, young and old, are able to educate themselves on the atrocities of the Holocaust. There's a $200,000 ad at line 296.3. Those are one-time funds to help market an incredible program we have at Georgia Public Television. They've developed some educational programming over the past decade that it's reward-winning across the board. And we wanted to make sure they have marketing funds to help parents and children know that those programs are there over the summertime, also to supplement school programming and after-school programming. And as we've had an increased number of homeschoolers, we want parents to know that's there as well. The numbers on student finance mostly come to the Senate based on just better, we get the budget later, we were able to have a little bit more updated numbers. And at the Secretary of State's office, the Senate was able to fund watermark paper and increase postage expenses related to precinct cards. We were not able to come to an agreement with the Secretary of State's office right now on the third-party ballot text auditing equipment, and we hope that that's something that we can continue to engage with as we go into the 25 budget, although we realize our time may have passed. At transportation, you'll see again that the numbers move basically to what we had previously on the Senate side, just being able to true up and have later numbers to match that, including the increases for rail at $8.5 million, local road assistance administration at $250 million, $500 million for the freight and logistics infrastructure projects, and $50 million for capital maintenance to make sure that our repaving projects are not stalled in March of this year. On our GISFIC projects, which are basically the bonds, now that the bonds are in cash for this year, this budget will fund the CDL facility in Richmond County at Augusta. It will fund $436 million for the construction of a new state prison in Davisboro in Washington County. It will fund $1.2 million towards the aircraft hangar located at the State Patrol headquarters in Fulton. It will also fund $3 million of the $6 million requested for uninterrupted power supplies for the Secretary of State's office and the election equipment there. It will fund $37.5 million for the Atlanta Farmers Market in Clayton County. It will also have $2.5 million for 42 vehicle replacements at the Department of Ag for the issue we heard about as that relates to the safety of those who are out doing food safety studies. $2 million for the Georgia Research Alliance for equipment. Fully funds Wilder Hall at Milledgeville. $3.1 million for the medical examiner's office at Bibb County, with a commitment from the governor's office that he will help us. He understands the importance of that facility and will help us with that in the FY26 budget. The Senate's budget also goes ahead and fully funds the Middle Georgia State University construction for the Eastman campus extension, the 2/3 necessary from the legislature there. And it funds design funding for the STEM Excellence Building at the University of North Georgia in Dahlonega. We were not able to come to an agreement and hold the funding for the Augusta University project, and that line at 367.44 does come off. But we were able to fund CDL pads in Paulding County and Union County in their place. The Hardy Hall renovation is fully funded in the Senate's budget here in the Conference Committee report. We had to back up on the Statesboro project and push that back into the FY25 again. And you'll see at 367.49 the funds for the Anne Frank exhibits appear there in GISFIC again, so they can lapse over to future fiscal years. The last two items in the bond projects are, one is $3 million for the Oglethorpe Mall Library, and $392 million that the governor brought as an increase of the revenue estimate earlier this morning for safety, health, accommodation, and accessibility matters related to the Capitol Hill complex and repairs and improvement for the historical Capitol building. The budget, I can talk more about that if you'd like for me to. The expansion there basically is related to this. Right now we have issues with many of our committee rooms are not open to the public. They're not accessible by the public, and we know we have to address that. We know that the CLOB has health concerns that have to be addressed. This is not a one-year project. This is a multi-year, as many as 5 to 10 year projects. But we think because of the funding we have right now, that the prudent move to do would be to go ahead and set all that funding aside now, rather than go back to General Assemblies year after year into the future and try to fund it that way. If I did not do a breakdown as to Senate ads or House ads or who won the game, because that doesn't matter. In the end, it's a budget that is reflective, I think, of 11 million Georgians, and hopefully your requests on their behalf are reflected here as well. You know this budget would not happen if we didn't have a lot of folks helping us. You recognized our Senate Budget Office the other day. I appreciate them again for their help to get here. The House Budget Office and the OPB, the Office of Planning and Budgeting for the Governor's Office, it'd be impossible to do it without them as well. So, Mr. President, if there are no questions, I'll yield the well and urge favorable consideration of the Conference Committee report to House Bill 915.
You do have one question, Senator. Senator from the 35th.
Thank you, Mr. President. Mr. Chairman, you mentioned the building accessibility, and I know that we're not ADA compliant, and we passed a bill 2 years ago, almost 2 years ago, that said that we would make the Capitol handicap accessible, but people still cannot go down to the mess, and they can't pull up to the well unless somebody can pick them up and take them out of there if they have mobility problems. So is that, you were saying it was going to be included? Is that a part of it, or what? Or does it have to pass over again?
Yeah,
It was a bill that passed and was signed.
Senator, certainly as it relates to the mezzanine, I believe those projects are all considered there. Also, ingress and egress and fire safety related to this building. You know that we run right at the fire marshal match quite often, but we should be open. People should have access to participate and petition and be a part of their government. I do not know about actually getting down here. That's not one that I am aware of exactly. But yes, ma'am, it's related to the accessibility matters, related to our committee rooms, related to our chambers, related to our buildings, but also to address safety and health issues. And if you've worked in the LOB very long, you know the health issues related to that building.
I do. The last thing is 121. Is that part of it too? Because there's a big sign there that says we are not ADA compliant. It's a little ramp right there.
You talking about the
And-
Capitol room?
Yeah, here in the
121?
Capitol on the
It's to
first
address
floor.
It's to address the Capitol building as well, yes, ma'am.
So it is a part
In
of.
that process, they would like to remain true to the historical nature of this building. So that is part of that plan.
Thank you.
Yes, ma'am.
You have one more question. Senator from the 33rd.
Just a point of order, sir. I ask for unanimous consent to excuse the senator from the 41st for business inside the Capitol.
Okay. Without objection, Senator from the 41st is excused. You have no further questions, Senator.
Thank you, Mr. President. I urge your favorable consideration of the Conference Committee report to House Bill 915.
Does any other senator wish to speak for or against the motion? Chair hears none. Question is on the adoption of the Conference Committee report on HB 915. All those in favor of adopting the Conference Committee report will vote yea. Opposed, nay. Secretary will unlock the machine. On the motion, the yeas are 52 and the nays are 1. The motion has prevailed and the Senate has adopted. Conference Committee on Report 915, HB 915. Recognize Senator from the 19th.
Thank you, Mr. President. I move that the Senate order House Bill 915 immediately transmitted to the governor.
Senator has requested that it immediately be transferred to the governor. Is there objection? As long as we have unanimous consent, without objection, we are, it will, motion granted. Secretary read Senate Bill 384.
Senate Bill 384 by Senators Hickman of the 4th and others, a bill to be entitled an act to amend Chapter 19 of Title 45 of the OCGA relating to labor practices relative to public officers and employees so as to provide for the development and administration of the state of Georgia as a model employer program for the recruitment, hiring, advancement, and retention of qualified individuals with disabilities at all levels and for other purposes. The Senate Committee on Insurance and Labor recommends that this bill do pass. Respectfully submitted, Senator Walker of the 20th District Chairman. That completes the order, Mr. President.
Recognize the Senator from the 4th.
Thank you, Mr. President. It's an honor for me to present this bill. This bill actually, as it came out of a result of the chairman from the 56th Study Committee on Workforce Development. And this is a great workforce development bill, and we will have several more, including today and then hopefully tomorrow. So this bill is called GAME, G-A-M-E, and that is to recognize and make Georgia the state of Georgia as a model employer. Model employer. What does that mean? That we will create a program for the recruitment, hiring, advancement, and retention of qualified individuals with disabilities at all levels and for all occupations for the state of Georgia. Georgia needs to be a model employer of individuals with disabilities. And by adopting the framework as outlined in this bill, that will happen. As y'all know, we have many qualified individuals with disabilities. And I'd like to recognize Charlie Miller and Charlotte Dinsmore for allowing me to bring this bill to the Senate. And according to the Georgia Council on Developmental Disabilities, Georgia has over 148,000 people of working age with intellectual or developmental disabilities. And of that 148,000, we only have 19,000 employed. That means there are 148,000 people out there that are qualified to have jobs and they're not working. No opportunities. So what does this mean? There will be a policy of this state to be a model employer of individuals with disabilities by adopting a framework for the state agencies that will consider the best, most promising, and emerging practices relating to the recruitment, hiring, advancement, and retention of qualified individuals with disabilities at all levels and for all occupations. And this shall be developed, implemented, and monitored by the state ADA coordinator. This bill has a provision in it that before September 1, 2025, and on or before each September 1st, each state agency in Georgia must submit a report to the ADA coordinator, a plan to increase employment opportunities for qualified individuals with disabilities. In that report, they've got to address the percentage of jobs that have been filled. They have to address goals and timetable based on workforce analysis. They have to address analysis of any barriers in existing employment. And they must address steps for recruiting. And not only those, also opportunities for advancement. Thank you, Mr. President, and I will take any questions.
You have no questions, Senator.
Thank you, and please vote green for this bill. Thank you.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none, and the previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none, the report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none, the main question is ordered. Questions on the passage of the bill. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 51, the nays are 1. This bill having received requisite constitutional majority is therefore passed. Okay, we made a little bit of an error, got a little ahead of ourselves on that last vote on the motion by the senator from the 19th on transmitting the budget directly to the governor's office. We needed a roll call vote on that, and so I'm going to call on the senator from the 19th to call the question again, and then I'm going to have you vote on it. And I'm sure 54 of you will vote yes and 1 will vote no, so we'll be good. We'll know exactly how it's going to go. So,
Thank you, Mr. President. I move that the Senate order House Bill 915 immediately transmitted to the governor.
is there objection? Without objection, those in favor of the motion will vote yea. Opposed, nay. Secretary, unlock the machine. On the motion, the yeas are 52 and the nays are 1. And this bill is immediately transmitted. Thank y'all for that. Secretary reads Senate Bill 399.
Senate Bill 399 by Senators Eccles of the 49th and others, a bill to be entitled an act to amend Chapter 4 of Title 20 of the OCGA relating to vocational, technical, and adult education so as to encourage and state expectations for the Board of Regents of the University System of Georgia, units of the University System of Georgia, and local boards of education, and for other purposes. The Senate Committee on Higher Education recommends that this bill do pass. Respectfully submitted, Senator Hickman of the 4th District Chairman. Senators,
I'm sorry, go ahead.
Senators Parent of the 42nd and others offer the following amendment, that amendment SB 399 by replacing transferable with transferable on line 6, by deleting technical college system on line 8, by deleting baccalaureate and inserting and the technical college system after university system on line 9. That completes the order, Mr. President.
Senator from the 36th, for what purpose do you rise?
Request unanimous consent to excuse the senator from the 34th for business inside the Capitol.
Without objection, the senator from the 34th is excused. I recognize the senator from the 49th to speak to the bill.
Thank you, Mr. President. Today, I come to you with Senate Bill 399. This bill encourages the Commissioner of the Technical College System and the Chancellor of the University System to coordinate their efforts to expand credit transfer opportunities between the two systems. The bill also requires the Commissioner and the Chancellor to produce a report every year for the Governor, Lieutenant Governor, and Speaker of the House of the following: a list of the courses that have been approved by the Board of Regents of the University System of Georgia and the State Board of the Technical College System of Georgia to be transferable between units of the University System and the Technical College System. Of those courses, the bachelor's degree programs for which each course has been approved as a prerequisite, and a summary of other coordination efforts between the two systems and their units. This bill also gives the Commissioner the power to certify prior to the start of each semester all courses that have been approved by the Board of Regents of the University System of Georgia to be transferable to units of the university system, and to identify the bachelor's programs for which each course has been approved by the board to be a degree prerequisite. The need for this bill was raised at a meeting of the Senate Workforce Study Committee in the summer of 2023 by one of my constituents. The goal is to provide more opportunities for technical college students to identify four-year degree programs for which some or all of their TCSG credits would transfer, and require the TCSG and USG to continually coordinate their efforts to expand and promote these opportunities for students. The long-term goal is to create more 2+2 program options where a student can complete a technical program in 2 years and be on track to complete a bachelor's degree program in only 2 additional years. On your desk, you have a friendly amendment from the senator from the 42nd, and I am in favor of that amendment too. Mr. President, I'll yield for questions if there are any.
There's no question, Senator. But you did say you're favorable to the amendment that's been
I
offered.
am, thank you. I'll yield.
All right. Senator from the 42nd, do you wish to, she's favorable towards your amendment. Do you wish to speak on behalf of it? All right.
Thank you, Mr. President. I don't want to belabor the point, but wanted to tell you that what it's about, simply because I hope we do work on it in the future, and it's essentially what the senator from the 49th was talking about, permeability between TCSG and USG for degree acquisition. This is the same thing, but with a specific look at students that have accumulated credits in the university system but not attained a four-year degree. What opportunities can TCSG and USG use to work together to see if those students might be eligible for an associate's, for example, instead of potentially dropping out with no credentials and a lot of debt. So I'm really grateful to Senator from the 49th and 28th, as well as our President's office, for helping with this amendment. And I'm happy to yield the well if no questions.
No questions, Senator.
Thank you. I yield the well.
Thank you, Senator. Does any other senator wish to speak for or against the measure? Is there objection to the previous question being called? No objection. We're going to take up Amendment 1, authored by the senator from the 42nd and co-sponsored by the senator from the 49th. Is there objection to Amendment 1? Hearing none, Amendment 1 is added. Is there objection to agree to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill as amended. All those in favor will vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 53 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed as amended. Secretary, read Senate Bill 429.
Senate Bill 429 by Senators Dolezal of the 27th and others, a bill to be entitled an act to amend Titles 28, 31, and 50 of the OCGA relating to General Assembly, health, and state government, respectively, so as to provide procedures and processes concerning the enactment of legislation and the adoption of rules and regulations, to provide definitions, to provide for the preparation and submission of small business impact analyses for bills introduced during sessions of the General Assembly and for other purposes. The Senate Committee on Regulated Industries and Utilities recommends that this bill do pass. Respectfully submitted, Senator Cowsert of the 46th District Chairman. Senator Dolezal of the 27th offers the following amendment, that Amendment SB 429 by replacing lines 26 through 29 with the following: prior to the convening of a session of the General Assembly, the Governor, and for other purposes. That completes the order, Mr. President.
Recognize the senator from the 27th. Speak to the measure and speak to the amendment too, Senator, if you don't mind.
Thank you, Mr. President. Colleagues, bring before you Senate Bill 429, the Small Business Protection Act. This bill is the centerpiece of the Lieutenant Governor's Red Tape Rollback Initiative. I know a number of you have been involved in giving input and feedback on what it is that small businesses across the state of Georgia need. Largely what this bill does is it puts guardrails around the rulemaking process, changes the definition of small businesses from 100 to 300 in code, allows agencies to relax regulations for small businesses, and puts in place zero-based rulemaking. I'll walk you through the bill quickly. Lines 26 to 79 implement what we're calling the small business impact analysis. And largely, you can think of these as being akin to fiscal notes, whereby the Department of Audits and Accounts, or OPB, will work together to prepare a small business impact analysis. And that analysis will estimate the economic costs and benefits that a bill would have on small businesses, including the cost of providing goods and services, the availability and cost of workers, industry and competition, and consumer choice, potential compliance costs. At this point, I will pause and reference my amendment that we worked with OPB on that really puts this directly in line with fiscal notes. It allows any member of the General Assembly to request the small business analysis when we're outside of session, but given the fact that they are under a much higher workload while we're in session, this limits who can request the small business analysis while we're in session to the Governor, President of the Senate, Speaker of the House, and the Chairperson of the committee. So that is the same, and that is a promise that we made in regulated industries to get this done on the floor, and that is the same as we currently have in place around the fiscal notes that we have done on a regular basis. Lines 85 through lines 116 require agencies to give certain notices with their rulemaking that contains an economic analysis and the impact of the proposed rule. Line 139 does what I referenced earlier, which it changes the definition of a small business to 300 employees and allows the agencies to reduce the economic impact of proposed rules on small businesses by establishing reduced compliance reporting requirements or different compliance timelines as well. Lines 176 to 254 implements a legislative review process of proposed agency regulations and puts a process in place for the committees of jurisdiction to pause agency rulemaking until we were in session. Lines 261 to 295 states that the effective dates for rulemaking shall be January 1st and July 1st based on when the rules are proposed. And then lastly, lines 299 to 352 put in place a comprehensive rolling review of agency regulations, whereby every 7 years, each agency, if their regulations have increased by 10%, they need to do a top-to-bottom review of those rules and provide for public input and just ensure the rules that we have on the books are indeed necessary and are not providing burdensome regulation to businesses in the state of Georgia. With that, Mr. President, I would lastly like to commend both your office, your chief counsel, and your chief of staff for their hard work on this piece of legislation and the way that they've worked with small businesses and businesses of all sizes throughout the state, looking to do what we think is the most significant regulatory rollback in decades in the state of Georgia. With that, I'm happy to answer any questions.
You do have a couple questions. Recognize the senator from the 37th.
Thank you, Mr. President. Gentlemen, yield.
I do.
Appreciate your work on this. You know, we get lobbied on the rope line all the time by governmental entities who pay people to come down here and talk to us about the impact it's going to have, the bills we pass are going to have on them. This looks at private sector industry, correct? The impact what we pass is going to have on individual small businesses who don't have a lobbyist on the rope line. Is that correct?
That's right.
One further question, if Mr.
Sure.
Gentleman yield. Does this put any limitations on us in terms of passing bills? I mean, if OPB gets backed up and behind, this is not going to slow down our process in any way?
That's correct. This does not change our ability. This does not
we're not
require
dependent
bills.
on them acting for us to be able to act as a
That's
legislature.
right. I assume you're referring to the small business impact analysis. That is voluntary. It is not required to have that to pass any bill.
Appreciate the bill. Thank you.
Senator from the 14th.
Thank you, Mr. President. Senator Yield,
I do.
do you have any sort of note from legislative counsel relating to the constitutionality of the bill?
I do not.
Okay. The Senator for the Yield.
I do.
Is there any concern that the process by which the legislature can object to the ratification of a rule is somehow akin to a legislative veto that violates separation of powers by inserting the legislature in the administrative process?
If you look, Senator, thank you for the question. If you look, we're actually really just kind of refining existing elements of code. As you know, committees of jurisdiction currently have the ability, they have to be informed of rules. They do have the process while we're in session. We have the ability while we're in session to object to those rules. This just gives us that ability while we're out of session as well, and then puts a mechanism in place where we return to session. It allows the agency to essentially appeal that decision, and then provides essentially an adjudication process through the committee, and then ultimately the General Assembly to either establish that rule as a rule or to overrule it as a
Okay,
non-rule.
thanks, Senator.
Absolutely.
Recognize the senator from the 42nd.
Thank you, Mr. President. Will the senator yield?
Yes.
With looking at, I've got a couple of questions, just two, but looking at lines 348 to 352, that if an agency desires to continue to repromulgate any rule or regulation, it has to go through the exact same process as new rules and regulations under this chapter. Wouldn't this be kind of burdensome and repetitive to require rules that have already been enacted and reviewed to go through the process again and again in order to stay enacted?
So this is a once every 7-year process. If you look at lines, I would need to actually find the line, but we do have this 10% provision in here, where if the agency rules do not change by more than 10%, they're actually exempted from this, what I'm calling at least, this zero-based rulemaking. But Senator, no, this is not designed to be burdensome, but this is designed to have the agencies go through more than just a automatic process of having their rules reviewed. We want to have them dive into the rules that do exist on the books and ensure that there's just not this kind of constant bloat of rules on top of rules on top of rules.
Okay, I think I see the 10%. Is that, you're referencing on line 307?
Can you say the number again? I didn't catch that.
I was looking for your reference to the 10%. I
Yeah,
see something about
307.
10% on line 307.
That's correct.
It has not increased the number of its rules and regulations by more than 10%. Right, but that still wouldn't exempt existing rules that have to go through the process again, which is what I was asking about, right?
It exempts the entire process. So it exempts the process whereby they bring essentially their package of rules forward for this analysis.
Okay, and then one other question. So I noticed that OPB and audits and accounts and potentially outside vendors as well will be key agencies involved in this process of trying to sift the information and get the information. I would think that we would need a fiscal analysis of what that's going to cost. Would like to hear your thoughts on that. My experience with audits and accounts is that they already, many times struggle to produce even the minimum of analysis of what they are currently charged with, to say nothing of this new, pretty extensive. I get that it's only once every 7 years, but it is certainly a lot of work. So please speak to that if you would.
Sure. When OPB came to testify on this, the only concern that they requested is addressed in the amendment. They did not express any concerns over either their ability to comply with this or the increased costs that may come about as part of it.
Did you speak with audits and accounts as well?
The Lieutenant Governor's office did, and again, there was not any sort of pushback there as well.
Thank you.
Recognize Senator from 36.
Thank you, Mr. President. Does Senator yield?
I do.
Do you have some examples of the volume of rules and regs for a large agency in our state government? Can you give any examples? This is a sweeping. This bill, it would seem to me, it has a sweeping impact, does it not, on tasking agencies with this extensive review?
Which review? I'm not sure
And
which
in light
review
of
you're
that, I'm
referencing.
wondering if you can give us any information about the bulk of rules and regs that a particular agency has.
I need a little bit of clarity on your question, Senator. Are you referencing what the every 7-year review, or are you referencing the request for the small business impact analysis, or are you referencing something else in the bill?
The every 7 year was what
Okay.
I was speaking
And with that
of.
in mind, do you mind restating your question for me?
Well, I'm asking you to give us some idea if you have some actual facts about the volume of rules and regs that one of our large agencies.
I don't have a
would
word count for you or a statute, a count of volumes. What we do know is as we've had conversations with businesses, this may not be
Oh,
high
that's
enough. There you go,
better. Yeah.
sorry. As we've had conversations with businesses all over the state, what we have heard is they feel they are constantly playing the catch-up game to learn what new rules are being put in place. There's no guardrails around when the rules will be put in place. And so what we believe this will do, and we're really modeling a couple different states that have gone down this path already, Idaho being one of those that says after 7 years, agency rules go away completely.
The
And
agency would go away, is that what you said?
the agency rules would
Oh,
go.
yeah.
So what we're looking to do essentially is to ensure that as these agencies are putting these rules into place, that they're, one, thinking about what the impact will be on the businesses that have to comply, and secondly, that every so often, we have 7 years in this bill, that there is a process whereby we take a wholesale look at the rules as a whole and review them from top to bottom and ensure that they are rules that continue to need to be in place. I'll give you an example of a bill that all of us voted for just a couple of weeks ago that was a piece of legislation, but I think is analogous. And we had the COVID signs. I carried that piece of legislation. There was a law on the books, not an agency reg, but a law on the books that we would all agree doesn't need to exist today. And I think that there are probably dozens or hundreds of those things as we begin to look from top to bottom that have been put in place perhaps before any of us got here, perhaps while we've been here, that as the agencies begin to look at the process of streamlining their regs, they will discover that some of those can go away.
I would just express, isn't it true that there is some, the old saying about going to meddling and unintended consequences of that, isn't it true, could cause some of us to have some concerns about what this would really, how this would play out in real life. And let me ask you a further question. The setting business, the term small business being defined as 300 or less employees, isn't it true that in my experience, typically 50 or less employees is that categorized as the way you describe small business in law? And I don't know where you drew 300 is a real big workforce. It's not a small business, I think, in the opinion of most people. So how did you arrive at 300 as opposed to the more typical small business description as 50 employees or less?
I don't know that 50 would be more typical. 100 is the number that we've had in code here, I think, for decades in the state of Georgia. I think that what we're seeing, and I can speak to a business that I helped start that's a 5-year-old business that has about 250 employees. And I can tell you we're still very much a small business. We're owned by a handful of people. Are you not able to hear me?
No, it's just side conversations.
I got you, no problem. We're still owned by a handful of people, ran by a small management team. My primary company that I own is 60 employees, and so we would be above your 50 threshold. But I can promise you, we're very much still a small business as well. Admittedly, whatever number we pick is somewhat arbitrary. There's not a scientific number where you set that, but I think that what we're trying to capture is the bulk of businesses in America that are owned by a handful of people as opposed to publicly traded companies. And as we kind of looked across the data, that 300 number seemed to be the sweet spot there before you cross the threshold into becoming a major or a large business.
And my final couple of questions are around this issue of ex officio members being able to come in and vote as though they had been serving on the committee. It kind of smacks of stacking the deck. It kind of allows a small number of people to really get over here and interfere in the executive branch without a long history in the subject matter and the policy of not having served on that committee. That's an unusual approach there, and I wonder what's behind that, and I think it causes some concern for many of us. And that is the appointment, that is people showing up and having a vote and being able to interfere, change, and mess with, topple agency regulations.
Well, Senator, I would just tell you that I've been added to as ex officio members to committees here in our own chamber. I was added, as a matter of fact, this morning to vet a bill from the senator from the 2nd, and I put my abilities up front as much on working on his bill this morning and analyzing it as I do every other piece of legislation that I look at in committee. So I would think of it as being in a very similar way to the way that we conduct our business here in this chamber.
But it is a way, isn't it true that you can really front load a process and get a result, by placing certain members on a committee that haven't been on that committee, but it allows a small handful of people to change the course pretty willfully.
I think the committee appointment processes in general can do that. If somebody were to abuse that, you can go upstream of that, not just to ex officio members, but to any appointed member. So I don't know that I share your concern on that, but I do appreciate your thought.
Thank you.
Recognize the senator from the 20th.
Thank you, Mr. President. Will the senator yield?
I do.
Would you agree with me that we are really blessed and fortunate in the state to have a lot of dedicated, sharp, fine people running our state agencies that are oftentimes doing it at a financial sacrifice? They could probably make more money in the private sector, but they believe in what they're doing.
I think there's countless examples that would prove your statement to be true.
Thank you. Would you further yield?
I do.
Would you also agree with me that it's the responsibility of the legislature to pass laws and not hired staff at these agencies?
I do.
And would you further yield?
I do.
Would you agree with me that the bill that you have before us strengthens and empowers the Georgia Senate and each and every senator in here to have greater input on the direction of policy with regard to these agencies that we otherwise would not have?
I would, Senator. I would go a step further to say that it empowers business owners, executives, managers, and even workers in this state to be able to come to us with their experiences and have a conduit and a touch point that they may not feel that they have today, which is to use you as their senator as their voice in interacting with these agencies.
Further question?
Sure.
So it sounds like to me, am I correct, that you're saying this will allow us to be more effective in representing our constituents?
I do believe it will, Senator, yes.
One last question.
Sure.
As insurance committee chairman, I get a lot of these rules and reg changes, these notices, all throughout the year. And would you agree that I'm a supposed part-time legislator and have actually another full-time job at home, and that when I get these notices in the summertime, oftentimes it's hard for me to respond in a timely manner?
I would agree.
And finally, would this bill help address that situation?
It won't help the part-time pay part of your role here in the General Assembly, but it will
response part.
help your ability to review various
Thank you for bringing
regulations.
the bill.
You have no other questions, Senator?
Thank you, Mr. Chairman, or Mr. President. I yield the will.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Question is on Amendment 1, authored by the senator from the 27th, the author of the underlying bill. Is there objection to Amendment 1? There is objection from, and we'll just put it up on the board. All those in favor of the Amendment 1 vote yea. All opposed nay. Secretary, unlock the machine. On the adoption of the amendment, the yeas are 51, the nays are 1, and this amendment has prevailed. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill as amended. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. Senator from the 8th, for what purpose do you rise?
Parliamentary inquiry, Mr. President.
State your inquiry.
Mr. President, isn't it true that every member in this chamber every 2 years is held accountable for the rules and regulations they seek to impose in this state? Is it also not true that it's not too much to ask for the folks that are creating these rules and regulations in these agencies to be held accountable every 7 years when we're held accountable every 2?
Senator knows what he speaks. Senator from the 14th, what purpose do you rise?
Parliamentary inquiry, Mr. President.
State your inquiry.
Mr. President, not true that reasonable people can disagree over the meaning of rollback.
I'm sure they can, Senator.
Thank you, Mr. President.
On the passage of the bill, the yeas are 40, the nays are 13. This bill, having received the requisite constitutional majority, is therefore passed by as amended. Senate Bill 440. Secretary, read the caption.
Senate Bill 440 by Senators Brass of the 28th and others, a bill to be entitled an act to amend Article 6 of Chapter 2 of Title 20 of the OCGA relating to the Basic Quality Education Act so as to provide for the Accelerated Career Diploma Program, to provide a short title, to establish and provide for the ACE Grants Pilot Program, and for other purposes. The Senate Committee on Education and Youth recommends that this bill do pass. Respectfully submitted, Senator Dixon of the 45th District Chairman. Senators Hatchett of the 50th and others offer the following amendment. Amendment SB 440 by deleting pilot on lines 3, 92, 99, 100, and 112 by replacing line 6 with the following: provide for the adoption of content and for other purposes. That completes the order, Mr. President.
Recognize the senator from the 28th. Speak to the bill.
Thank you, Mr. President. Colleagues, it's an honor to bring you this fine piece of legislation. This bill really comes out of our good hard work we did over the interim with our study committee, with SR 175, the senator from the 42nd, the minority leader, senator from the 25th, and several House members got together to really look at dual enrollment and figure out two things. We wanted to, number one, make sure that it was going to be sustainable. And number two, we wanted to simplify it. Because what we found was in high demand career fields, there's a list out there. Not one list, but two lists. And so what this bill does, SB 440, we're going to take it down to one list. Another thing this bill does is we're going to make sure it stays sustainable by getting control of that list. We're also going to clarify that high school academics in statute versus regulation. And another thing we're going to do to simplify is funding for dual enrollment is really scattered throughout. And so what we want to do is the funding is going to come from one source, and ultimately that is what this bill does. We're adding clarity and flexibility to the dual enrollment program. And we're saying that any student under accelerated careers diploma program will be fully funded under the dual enrollment. And it's important to note that our return on dual enrollment investment is significantly less at our technical colleges. A dual enrollment student at one of the world's finest universities, University of Georgia, for 30 hours, it's $362 a credit hour, which equates to $10,860. Same student at GSU, 30 hours at $300 equates to $9,000. And a private student is 30 hours at $250, which equates to $7,500. So that's for 30 hours. For 62 hours at $100 a credit hour at a technical college, these kids can come out with an AAS degree, that's an associate's degree, at $6,200. So we're saving not just the state money, we're saving our students' money and our parents' money. So unless you hate children or puppies, you should vote for this bill. Senator from the 19th. Do you hate? I can't ask questions. I won't. Anyway.
You have no questions either, Senator. God bless. I tell you what. I recognize the senator from the 50th to speak to the amendment.
Thank you, Mr. President. I want to start by thanking Chairman Brass for bringing this bill. I'm pleased to see that, I want to start by thanking the distinguished rules chairman for bringing this bill. I'm pleased to see that it will extend the sunset on the pilot program created by Senate Bill 86, a measure that the governor supported and has already served 1,438 students since it began in 2020, according to the technical college system. The amendment I bring before you does two things. One, it cleans up the high school academic requirements at the request of the Department of Education, and it clarifies that the ACE grant will be a permanent program, not a pilot program. The ideas present in this bill stem from the Senator, Mr. Rules Chairman's work on the Joint Study Committee on Dual Enrollment for Highly Skilled Talent at Younger Ages. I look forward to carrying the Governor's administration bill, House Bill 982 in the Senate, which also resulted from the work of that committee. I urge everyone to vote in support of this amendment and the bill to enhance the state's efforts in strengthening our high-demand career pipeline. With that, Mr. President, I'll yield the well.
Senator is yielded. Does any other senator wish to speak? Senator from the 51st, what purpose do you rise?
I'd like to ask for unanimous consent to excuse a good senator from the 18th for business in the
All
Capitol.
right, without objection, the senator from the 18th is excused. Senator from the 20th, what purpose do you rise?
Parliamentary inquiry, Mr.
State your
President.
inquiry.
Didn't the senator from the 28th, I believe he enlisted love of puppies for reason to support his bill? And isn't that better than his school bus analogy he gave a few years ago?
Oh, the senator knows what he speaks. Does any other senator wish to speak for or against the measure? Is there, Senator from the 28th, would you like to close the debate? You'll waive, okay. Question is on adoption of Amendment 1, authored by the senator from the 50th. Is there objection to adoption of Amendment 1? Chair hears none. Amendment 1 is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill as amended. All those in favor vote yea. All opposed nay. Secretary, unlock the machine.
This one has a substitute. No amendments. It's not the lane drags. Same place.
On the passage of the bill, the yeas are 52, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed as amended. Secretary reads Senate Bill 10. Senate Bill 10.
Senate Bill 10 by Senators Jones of the 10th and others, a bill to be entitled an act to amend Article 2 of Chapter 11 of Title 16 of Title 40 of the OCGA relating to offenses against public order in motor vehicles and traffic, respectively, so as to provide for an offense of knowingly attending and facilitating an illegal drag race or lading drags and for other purposes. The Senate Committee on Public Safety recommends this bill do pass by substitute. Respectfully submitted, Senator Albers of the 56th District Chairman. The Senate Committee on Public Safety offers the following substitute to Senate Bill 10, a bill to be entitled an act to amend Article 2 of Chapter 11 of Title 16 of Title 40 of the OCGA relating to offenses against public order in motor vehicles and traffic, respectively, so as to provide for an offense of knowingly attending and facilitating an illegal drag race or a laying drags, and for other purposes. That completes the order, Mr. President.
Recognize the senator from the 10th.
Thank you, Mr. President and members of this body. 3 years ago, Governor Kemp signed the J. Mize law into the J. Miles Act into law. And I just want to take a quick moment to tell you who she was. J. Miles was 52 at the time when she was struck by a car and killed in DeKalb County. In the vehicle with her was her 16-year-old daughter at the time named Skylar. Ms. Mize is from DeKalb County, and her mother, Miss Bobby Sanford, is a very prominent family in DeKalb County. As a matter of fact, the Porter Sanford Center is named after her husband, who was a very prominent county commissioner for a very long time in DeKalb County. When the governor signed the bill into law 3 years ago, she whispered in my ear, she said, "Senator, you need to do more work on getting rid of this scourge that's on our community called drag racing." In front of you today is Senate Bill 10, which is the latest addition to our efforts to do exactly that. Senate Bill 10, and may I also thank the senator from the 56, and I know Judge Gary Jackson from Atlanta Magistrate Court is watching on television, so I told him I would mention his name. Thank you, Judge, for your input on this legislation. But Senate Bill 10 creates the act of stunt driving and stunt and reckless driving. The heart of this bill is really on page 2, line 22. This bill seeks to curb those who are knowingly present and actively participating in drag racing and land drags. There's not our intention or my intention to try and trap anyone who just happens to be going by and notices this activity, but you have to be knowingly present and actively participating. Over on page 4, there's a slight increase from the fines from the original bill. And further down on page 4, it simply says that in the event from the fines, if there's any property damage or loss of life, that the first 12 months of the sentence shall not be suspended from what Governor Kemp had signed into law 5 years ago. Over on page 6, in section 4, this section was fully vetted by the magistrate court judge that gives them more discretion on how to handle those that are participating in drag racing and, of course, laying tracks. And, Mr. President, that's pretty much Senate Bill 10 in its entirety.
And you have no questions, Senator.
And I thank you. I yield well. Encourage your favorable support of Senate Bill 10.
Senator from the 14th, you wish to speak on behalf of this bill?
Thank you, Mr. President. The hour's late, the mood's weird, so I'm going to be brief. I'm going to be voting no on the bill, and I look forward to the campaign mail, mainly just because lines 22, 23, which the author characterizes as the heart of the bill, I think are too vague. It says any person who's knowingly present and actively facilitating. I think what this effectively does is criminalizes being at one of these things. And, you know, the context of this year is we've got these conversations about the First Amendment and about, you know, minor misdemeanors that could be wrapped up in things like protest or just being in public spaces. I do think in general it's a dangerous road to walk down to add more criminal liability to being in public spaces, because I do think facilitating is vague, even if the example later in that portion is a little more concrete. And so with all respect to my colleague and with all respect to everybody who hates drag racing and the noise it makes and the public safety problems it causes, I'm just going to go out on a limb and let y'all send some mail because of the First Amendment public space implications. And that's all I got. Thanks, Mr. President.
Recognize the senator from the 39th.
Good afternoon. I'll be very brief. I think this bill, as somebody who represents Atlanta, is a very important bill. We did try to do some stuff a few years ago, but it did not quite go far enough. In Atlanta, we still have these problems. I went on a ride-along with the Georgia State Patrol, and that particular night in Gwinnett County, there were 200 cars gathering, and people gathered specifically for the issue that this bill is referencing. I personally know somebody who was caught in between two people speed racing down the highway and almost lost her life, and continues to be in rehabilitation for that. This is an important bill. I plan to support it and hope you will too. Thank you. I yield the well.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 46, the nays are 6. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the Majority Leader for a motion.
I'd like to make a motion that we adjourn the Senate until 10 a.m. Tuesday, February the 27th.
The Majority Leader has moved that the Senate stand adjourned until 10 a.m. on Tuesday, February 27th. Secretary, read the announcements.
Okay. The Rules Committee will meet upon adjournment in room 450 of the Capitol. That completes the order, Mr. President.
The Majority Leader has moved that the Senate stand adjourned until tomorrow morning, 10 a.m., where I promise you it will be a long and tedious day. I will assure you of that tomorrow. So, all those in favor of the motion will signify by saying aye. All those opposed, no. The ayes clearly have it. We're adjourned.